no question of 1/3, 2/3. You have to abide by the discipline, and the only defense is paragraph 4. To say, therefore, the whole argument is that I am 40 or I am 30 or I am 20 is neither here nor there. For the purposes of the 10th schedule, this is irrelevant. So what has happened is, I am the party, I am the Shivsena. I am recognized by the Speaker of the Shivsena. You are members of the original political party who are represented in the House. You have done an act contrary to, in collaboration with others belonging to the opposition party, done acts which amount to voluntarily giving up membership of that party. Now, if this is decided by the Speaker in these petitions, what will it relate back to? Relate back to what happened after 21st of June. There are 34 of this judgment clause. The act of disqualification occurs when a member voluntarily giving up his membership of the political party or at the point of defiance of the way wished to him. Therefore, the act that constitutes disqualification in terms of para 2 is the act of giving up or defiance of the whip. The fact that the decision in that regard may be taken in the case of voluntarily giving up by the Speaker at a subsequent point in time cannot and does not postpone the incurrence of disqualification by the act of the legislature. It will therefore relate back. Now, if it relates back to us, then it will relate back to what happened between the 21st of June and thereafter. What the Election Commission is seeking to do is to decide the status of the party, so-called party, on 19th of July. But what will happen on the 19th of July thereafter has nothing to do with what's happened before. Because what has happened before is that they have given up the membership of the party. Let's ask the question, the very important question that we threw him out of the post. CRA, Volume 2. First, we show the letter to the Election Commission. Now, let us kindly see the letter we wrote to Shinde on the 30th of June. It's much before 19th July. At page 321. Convenience Compilation, Volume 2, page 321. Yes. Dear Mr. Shinde, you have been indulging in anti-party activities and have also voluntarily given up membership of Shivsena. Therefore, in exercise of power vested in me as the Shivsena Paksh Pramukh, I remove you from the post of Shivsena leader in the party organization. So, I tell him that you have already by your acts given up membership of the party. So it's not a question, of removing him from the post. Now see the letter we write to the commission at page 333. This is on the 1st of July. Yes. Second paragraph. As you are aware, Eknath Shinde has indulged in anti-party activities and has voluntarily given up.
1488.
1488.
PDF.
As you are aware, Shri Eknath Shinde has indulged in anti-party activities and has voluntarily given up membership of Shivsena. Consequently, he was removed from the position of Shivsena leader in the party organization set up by Shivsena Paksh Pramukh Shri Uddhav Thackeray in terms of party. Just to mention that he was not an elected member in the party organization. He was nominated by the leader. Uddhav Thackeray is the president of the party from 1990 to 1923. I still remain the president of the party. The now. 2018 to 2023. As per the records of the election commission. So I remove him. He was a nominated member. I remove him. I tell the commission and I tell him that you have voluntarily given up membership of the party. So it is my case, that he is not even a primary member of the party. Not by virtue of the fact that I have thrown him out. By virtue of the fact that under the 10th schedule, he has committed acts in terms of which he is disqualified by virtue of 218. My learned friends are saying that this has nothing to do with the election commission. As a matter of constitutional law, how is that possible? In other words, the election commission will decide and will presume as a matter of law that he continues to be a member of the party. Whereas this under the 10th schedule, by his acts, he is no longer a member of the party. So, how is that possible to say that no, these are two different silos? Now, and therefore, I am saying because there is no defense now available under the 10th schedule at all as far as paragraph 3 is concerned or any other paragraph is concerned. The only defense available is merger. And in the context of merger, if your lordship looks at paragraph 4, just give me a minute. Very interesting. Should not be disqualified under subparagraph of paragraph 2, where original political party merges with another political party. And he claims that he and any other members of the original political party have become members of some other political party. So, if he is a member of the Shivsena and Shivsena merges with somebody else, the stamp of Shivsena is effaced. He is no longer Shivsena. So he merges with another party, or he has another party merge with him and he forms a new party. The new party or the merged party becomes his original political party. I hope I made myself clear.
Yeah.
So it becomes his original political party, so he's washed his hands off to Shivsena. That's the consequence of paragraph 2. Then he can't maintain a petition under paragraph 15. Because he's either merged or he's formed a new political party. And those who are left behind, that is, who are less than one third, because 2/3 makes others, those belong to the original political. In this case, us, of course, in the absence of a merger. So, therefore, the nomenclature of the original political party, which was attractive when they were first elected to the House, they've lost that in the paragraph. Now, see what my learned friend read. He said, please read the last part. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Naturally, because we are now talking about formation of a new party. Therefore, you are no longer the original political party. This will take a bit of time, but I'm also happy.
Mr. Sibal, you can conclude your argument.
No, you are rejoined our council.
They have argued for this.
No, that cannot be tit. No, that cannot be tit for tat that he has taken 2 hours.
Cited certain fragments, which I.
All right, Mr. Sibal, you can deal with the judgments. You can tell us what the point of distinction is. What we've been noting along is you go along and what the point of difference is.
I have no problem. I can finish it 10 minutes. Now, therefore, now let's come to paragraph D.
Paragraph D of?
Okay. Our Mr. my colleague Maninder Singh cited paragraph D of our petition.
Okay, the ground. Ground.
Oh, yes, the grounds. What your prayers.
What I was saying is there are certain judgments that have been cited that are wholly inapplicable. I just want to point out that there are 2 other judgments. It's all right. Read the whole paragraph.
No,
Let's read the whole paragraph.
Ground D of ground page 8, right?
Because and children. That's the point, Manoj.
But that will be considered, Mr. Council, at the time when we consider the question of disqualification.
But if you lordship allow the election commission to go on and hold, and that's the point, Manoj. Either your lordship says one has nothing to do with the other, and if your lordship is saying you will consider it at that time, that means that has something to do with the other. I'm not saying, I'm only saying, Manoj. He says great repercussions. Because in this situation, then X number of people of a political party who are in power can be named away. Governor will give them votes, and we'll go to the election commission and say, you declare us the simple words. And that's the consequence, which is sought to be prevented by taking away the third paragraph 3 of the 10th schedule. The whole purpose of taking away paragraph 3, let's not have these spits. Then paragraph 36 minutes. Also read it half of it. I'll just read that minutes. Page 10. On the contents of paragraph 24 to 32 are denied. It is submitted that clearly claiming the support of a majority of SSLP cannot be looked at in isolation. If the delinquents were so keen on a change in party leadership, they ought to have approached the election commission in the very first place itself, having committed a series of anti-party activities culminating in the blatant violation of Whip 3.7 as well as of 4.7, and having read the writing on the wall as to their imminent disqualification from membership of the assembly, the splinter group has now rushed to the election commission to claim that they are the real Shivsena. But this is what they did. They did it on the 19th of July, knowing full well that the writing is on the wall. Then, my learned friend cited two other judgments. First, Kerala judgment where there was no disqualification.
2021 4K 23, he said at page 50.
Well, then, Palani,
But he didn't read it out.
let's see Palani Swami, what does he cited?
Palani Swami.
Well, that is a pure issue of why the matter was pending before the commission. I myself argued it. The question is, who should the symbol go to, or should it be frozen? Interim symbol, which has nothing to do with the tension. Rani Swami had nothing to do with the tension. Matter was pending before the commission. There were rival claims. And the question was, who should get in the interim symbol? What has that got to do with this issue? The third judgment by learned friend cited is the Kerala judgment. So that my colleague.
That Mr. Jetmalani
cited.
He didn't cite.
Paragraph 4,
He really just gave us a citation.
He has no doubt.
No, he said that this is the first time the court is decided.
Page 51.
Yes, now, I just note paragraph 6 of that judgment says, the learned single judge has also failed to appreciate the fact that even when the writ petitioners claim that rival groups exist in the party and their group is the party, no petition under the 10th schedule has been preferred. It's not a case of the 10th schedule at all. Para 6 at page 172, 3 mothers. Para 6
at page 173.
Yes. It's not a case of any application also for disqualifications. Then he cited Kanhaiyalal Umar. Now, Kanhaiyalal Umar, brothers, it is a writ petition challenging the power of the commission under the symbol law. The violence of the symbol law. What has that got to do with disqualification? That's Kanhaiyalal. As well as all party Hills Leaders Conference, brothers. That was a case. The election commission is a tribunal for the purposes of 136 before 1985.
Yes.
Now let's kindly see what the notice of the commission is to us. Page 701. Compilation Miller's document, volume 2. Kindly see paragraph 4 on due consideration. This is their notice. You also have that? That is 701.
That is document number 9.
Yeah, on due consideration of the totality of information available on record to the Commission, as summarized above, the Commission is of the opinion that there are two rival groups in Shivsena party. So he's already assumed that there are rival groups in Shivsena, when the whole question is whether he's a part of Shivsena or not. One led by Uddhav Thackeray and the other led by Eknath Shinde. So you assume this, Malad, on what basis do you assume this? And each group is now claiming the party. That's not my thing. I am saying he's no longer in the party, he's voluntarily given up. How does he, on what basis does the election commission come to that? Assume that fact. Matters require substantive. Now see next paragraph. In order to place both the rival groups on even keel, but this is very strange. Both the rival groups on even keel. Where does he get that from? So what the election commission is doing is, I don't care what's happening under the 10th schedule. I'm not bothered what's happening under the 10th schedule. Even if you are deemed to be disqualified, even if you are voluntarily given up membership of the party, I will treat you on an even keel. I will assume you are still a member of the party. Whereas the election commission can't assume that. We have already written to the election commission that look, he is no longer a member of the party. He is voluntarily given up. So on what basis does he say not even keel? And to protect their rights and interests and going by the past precedent, Commission has directed that the documents submitted by the rival group be exchanged and reply given. Then was interesting. The steps envisaged under paragraph 15, prior to hearing of two rival groups or others, if any, inter alia require both rival groups to submit their respective documentary evidence to support claimed by them in the organizational and legislative wings of the party. Now that's very important. So three elements in these notices, which according to me are completely contrary to the record. And they are aware of my letter, at paragraph 2, 2A. Sorry, 2B. Anil Desai by email forwarded 3 letters whereby it was mentioned that the following members have been judged in anti-party activities and have voluntarily given up membership of the party. Now, Commission can't decide that issue. So now let's go back to the last part, 702 that I was reading. Support claimed by them in organizational and legislative ways. But let's pause here for a minute. Just reflect on what happened. The 30th of June, they were all sitting outside. There was no organizational wing. They were in Guwahati. They were sending letters from Guwahati that I throw you out, I am the person, I am the chief whip. Gogavli is the chief whip. Your person. Where was the organization? There was no organization. There was no activity in the organization. Evidence of support claimed by them in the organization. There was no support claimed by them in the organization until the 30th of June. Even after that, there was no support. It only comes later. Secondly, on the legislative wing, your lordship knows that the judgment said that has to be considered. Now, if the legislative wing, according to us, all 40 of them, are deemed to be disqualified, well, how will the election commission consider it on an even keel by virtue of proceeding under paragraph 15? The very foundation of it is lacking. You are presuming a foundation which doesn't exist. You are presuming that they are members of the Shivsena when they are voluntarily resigned. I have informed you about it. And you say we will treat it as an even keel. Now, nobody disputes further than them. A big argument is made about 324. Nobody disputes that power. Who disputes the plenary power of the Election Commission? Not I. We're talking about the interrelationship between proceedings under the 10th schedule and proceedings before the Election Commission to decide on symbols when one impacts the other. And the priority is whoever started proceedings first will be given priority in terms of decision making. If it is an afterthought, then after everything has happened and you have voluntarily given up membership of the party and thrown out an elected government, then you go to the Election Commission on the 19th of July and say, I am the party mother. Certainly the Election Commission can't get precedence. Now, as far as plenary power is concerned, and this is the last point I wish to make. Paragraph 15 deals with an admitted position that we are all members of the same party. That's how paragraph 15 came into existence in 1968. There was no question of 10th schedule. There was no question of election. And what used to happen, the history of litigation in this area would have shown that every faction used to throw out membership, members of the other faction. And obviously, Election Commission could not decide those issues. So they say, okay, let both factions come and we'll see who has the support. But that the foundation of that went away the moment the 10th schedule came. Then the question of factions didn't arise. Then the question of disqualification came. The purpose being that those who are disqualified cannot get the symbol of the party. Because they have voluntarily given up membership of the party. Otherwise, why have that? Why you had 2-1 at all? If it is only a question of the legislature, argument was this all relates to the legislature, that relates to the party. But then why have 2-1 at all? So paragraph 15 presupposes legitimacy in the context of membership of the party and two factions arising out of legitimate membership claiming to be that party. That is paragraph 15. Paragraph 15 doesn't allow the Election Commission to disregard what has happened under the 10th schedule. Because if it does, what will happen is, supposing your lordships decide in my favor, let's assume your lordship will decide in my favor ultimately in the petition, what will happen? They will say, we are the party. Now what's left in this matter? Unturn the clock back. Election Commission has decided. So it makes my petition infectious. If our lordship decide against me and say, no, what happened was perfectly legal, in any case, they will get the symbol. So they are not in any case prejudiced. Why is it that we want this to go on today? When your lordship can decide this matter in October, here the matter decided. What is the great urgency today that this must go before the Election Commission so that the other freezes the symbol or gives it to somebody without having this matter decided? And then they say, look, my speaker is there, my speaker will decide. How will the speaker decide? Because this court has said on the 29th of June that everything that has happened after 29th of June is subject to the orders of the court. They must have glossed over. So how will the speaker decide that issue? And then the larger question is whether when they go to the deputy speaker that you are disqualified because we have moved a notice of removal against you, mother. The speaker said this hasn't come from any source at all. It has come from an email that I'm not even aware of. And it is rejected. And that fact is suppressed when they come to this court. And mothers, what's interesting is this course, and I'm sorry, mothers, I'm taking time, I didn't want to take too much time on your lordship. But let's see what the order of the court is on the 27th. Then show me careful. It says, meanwhile, as an intent, Yeah.
So what is the date of the order?
Date is the 27th of June.
PDF 2151.
2151.
Compilation of orders and pleadings is there in page C, Madhus.
Thanks. Yeah.
Meanwhile, as an interim measure, because it's about a few paragraphs.
Yes, we've got that.
On
Yes,
page 3.
meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the Legislative Assembly to submit their written submissions up to today by 5:30 is extended to 12/7/2022. Correct, Madhus? Now see Kyoto Holo. Para 110. The argument is he gave us 2 days time. He gave us 2 days time. Natural justice. That's the argument. Therefore, this court extended it. Now let's see the order. See Kyoto Holo. Para 110. Order is in the teeth of 5 the constitutional bench of this court. Then the government was toppled. Then we came to court that look, the consequences of this is the government will topple. Then the judge said on 29th, but it is all subject to what we will decide. What does Kyoto say? I'll read it. No need for curiosity. In view of the limited scope of judicial review, it is available because in para 6. And also having regard to the constitutional intentment of the status of the repository of the adjudicatory power, Speaker, Chairman, judicial review. Prior to the making of a decision by the Speaker, Chairman, and a legitimate action would not be permissible, nor would it be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceeding. And such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. There is no power to interdict the proceedings. It is only after the decision is taken that you can challenge it. That's the constitutional judgment. So where is the question of coming to court and saying you gave me only 2 days notice? Wait for the decision of the Speaker, you challenge it. The result was, because the court extended it for X number of days, the government toppled. And then we came to court and said, we said, in fact, I remember I had told the court that this is what's going to happen tomorrow, which is simple, why do you worry? We have passed an order saying everything is subject. Now they are saying it doesn't matter. And what is this inner party democracy? I have not understood. Inner party democracy in the context of 10th schedule means what? That you can topple any government you want to topple by joining hands with the opposition. It has no difference. It makes no difference. Inner party democracy is in the context of your continuing to be a member of the party, not doing anti-party activity, and air your grievances within the forum of the party. Inner party democracy doesn't mean that you violate the 10th schedule and say I have the right to violate it, and this is inner party democracy that's been given up. This concept of inner party democracy by violating the 10th schedule, not going to the organization, staying in Ahmedabad and Guwahati, doing acts outside the house, and then going to the election commission on 19th of July when you've done what you had done and joined hands and formed government and will become a chief minister. And then you say that, look, as far as I am concerned, the election commission will now decide whether, in fact, if this is the law, I think it bodes ill for the future of elected governments in this country. Thank you.
Thank you, Mr. Yes, Mr. Yes, Dr. Sanghi.
I'll give it in point form. What is the crux of the case or the nature of the phrase voluntarily giving up membership of the party? Whereas in actual practice, 90 if not 95% of acts or omissions coming under 21A relate to activities outside the house by the very nature. examples out of hundreds. Going and was bashing the party or abusing it outside. Going to a rival party and accompanying them for a topic. Indeed, going to the governor with a rival faction. Now, all of these have nothing to do with what you are doing inside the house. Voting or not voting in a trust board, voting or not doing this, etc. A very important judgment of your lordships had occasion to consider it. I'm going to take only 5 minutes. Ravi Nayak. Before I cited the book, out 1994, supplementary to SCC 641. Ravi Nayak was said that, and this is practical, no person comes and says, I have defected. While it's being given to your lordship, kindly appreciate the nuance of this clause. Nobody ever said, there is no case that says, I have done anti-party activities or I have defected.
He says speaker can infer.
The word is infer. The operative word on which Ravi Nayak is based is, it is inferred A and B by conduct. That's the heart of the principle. Just read para 11. Just that. Now, this I will read to save time from the middle. All of 11 is important, but just read that middle practices. Middle of para 11, my lord. The said paragraph provides for disqualification of a member. They are talking to a Eknath, of a house belonging to a political party, quote, if he has voluntarily given up his membership of such political party, unquote. The words voluntarily given up his membership are not synonymous with resignation and have a wider connotation. Now, kindly read this. This is what I am relying on, but it's coming now. A person may voluntarily give up his membership of a political party, even though he has not tendered his resignation from the membership of that party. Even in the absence of a formal resignation from membership, and inference, the operative word, can be drawn from the conduct, that's the second operative word, conduct, of a member that he has voluntarily given up the membership of the political party to which he belongs. Now, fellas, if this is the law, then your lordship's fellas has to consider, and not your lordship fellas, the persona designata exclusively constitutionally entrusted with this power is one person, the speaker. That persona designata will have to consider no one else. What you did in Surat, what you did in Guwahati, what you did outside, good, bad, or indifferent, what you did with the governor, is directly Ravi Nayak. And inference can be drawn that you gave up. Now, if you gave up, then how do you operate clause 15 on the assumption that this is one faction of the party, this is another faction of the party? So, complete conceptual contradiction is my point number 1. And because that is what is happening. Your lordship may kindly read again to save time, I will not read it. The 4th of August 22 order of this honorable court. The last 4 lines, and we all appear in this, was based on a clear understanding at that time by that honorable bench that the election commission would not proceed. And the last 4 lines of that read like this. According to the learned senior counsel, that is Mr. Datta, it says so. The proceedings may take some time as voluminous evidence is usually submitted by the parties which must be considered by the EC. The learned senior counsel therefore states that no orders may need to be passed by this court interdicting proceedings before the election commission. In these circumstances, we grant liberty to the petitioner to file an application before the EC for seeking time. Such applications are filed 3 times. Time was given with consent. There is no formal order, no doubt, but this is endured from the 3rd week of July till today as we speak in October. September. That is the point number 2. Point number 3 is whether the balance of convenience clearly endured for further 1 month. If this is endured already, it does not at all cause them irreversible. However, your lordships not protecting us causes us irreversible. That's point number 3. This is point number 4. This is ground of IAM. your lordships, because I don't think should be deterred by the form of an IA versus the substance of what we are. That's the simpler answer. But two more important answers for us in law. It would be, according to me, quite quaint if your lordship said that because an IA, your lordship can't decide this matter, it's outside the scope of the amendment. But there are two other answers, factually wrong. Number one, we find several writs, including what your lordship will call the all-encompassing writ, which is number 493 of 22 on 8th of July. Prior to that, your lordship has 4 other writs in which this order of subject to outcome has also been passed. Prior. Election Commission is a subsequent development. It's as simple as that. It's a subsequent development. My writ 493 covers almost all the issues we have argued. 1 week, 10 days after the 8th of July, when I filed the writ, on 19th of July, this election commission is initiated. I filed an IA saying that this is a subsequent development. Why your lordship is hearing the main matter, please defer it. Because is that something so startling and beyond jurisdiction, like a fundamental lack of jurisdiction, that your lordship cannot touch it? Therefore, that is, well, I hope, not their best answer. Now, Willis, one other thing, and I'm done. There is 2 paras of Rana very important. One, my learned friend Mr. Paul read para 25. He did not read para 27, which is the following para after 1, which is very important. And the second para is 48. So these 2 paras I'll take 2 minutes on. My learned friend Mr. Paul read the sentence to be very
Para 27 and 48. There's
Yes.
just one more. Let me go to grammar.
27 is the answer to 25, which was read. The context is placed in 27, which was has to be read now.
Just give us, just give a moment. Page 192, right?
Yes, so my learned friend read para 25 and he read this sentence actually, virtually the sentence alone. Para, classical C. The power to recognize a separate group in parliament or assembly may rest with the speaker on the basis of the rules of business of the house. But that is different from saying that the power is available to him under the 10th schedule to the constitution, independent of a claim, mark word independent, of a claim being determined by him that a member or number of members had incurred disqualification by defection. That's a sentence Mr. Paul read. Now, the sentence which connects this is para 27 page later, where it is viewed as a continuum, as a part and parcel, and it is a continuum of split, merger, and disqualification. All are interconnected and have to decide by the speaker. Can you read that? This is para 27 from classical D for Delhi. In that context, the speaker cannot say that he will first decide whether there has been a split or merger. There are 2 concepts there. As an authority, and thereafter decide the question whether disqualification has been incurred by the members by way of a judicial adjudication sitting as a tribunal. Next sentence is crucial. It is part and parcel of his jurisdiction as a tribunal while considering a claim for disqualification of a member or members to decide the but also in the context of the 3 raised by this person, that they have not incurred split in the party or in view of a merger. It is part of one continuous process of the speaker, who is a persona designata by the constitution, no less. Now, while your worship is on this, just let me finish on 48 of the same judgment. Also, not this great. This is just 2 lines. This is just to correct, but as one out of the hundreds of examples, myriad examples which occur in 218 of voluntarily giving up. This case involves the very specific case, the act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to an act of voluntarily giving up the membership to the party or to speak it to said members and party. It is because all over the press and repeated that they went on this case with the other faction to the other party to the all admitted documents, all was on the record to the governor, doing exactly what Rana records in Paramatma. My fifth point is that your lordship is cited first. I want to make a general fifth point and then tell your lordship. I make bold to say, and I've checked with Mr. Devdas Kawat, who is very meticulous of this subject. 10 times I've told him. Not one single case. I repeat, lordship recorded my submission. It's a rather broad thing, I don't want to make a wrong statement. Not one single case where the interaction and interplay between a disqualified or disqualifying pending matter in a symbols case. Not one case. I can't put it more widely than that, but I'm open to challenge on that. From that follows point number 6. One case is cited, which is that Omar, etc. 1985, 4 SCC 628. Just note the citation, I have not taken off, just note the difference. The only case cited is 1985, 4 SCC 628, where para 1 notes that this is a challenge to the constitutional validity to the government. For one. Number 2, no issue arising in that case of disqualification. Now we have the 10th schedule. What was the 10th schedule in a descriptive manner saying now we have 10 schedules, that's para 10. That one para becomes the springboard, erroneously and wrongly, of citing that case, suggesting that there is an interaction between the symbols jurisdiction and disqualification. Nothing whatsoever. It's a completely inapplicable and irrelevant citation for this subject. May I end by saying, after thanking a lot for giving us time, that if the party, if there is, why should we kindly go back to the origin? Why did the 10th schedule use 2 broad words? Actually, this intra-house issue was the whip issue normally. Of course, it can apply beyond the house also, I'm not saying, but I'm saying that that was the focus. They deliberately and consciously used a very much wider concept. That concept falls directly in this issue to be decided one way or the other by the primary persona designata, the speaker's jurisdiction. It may or may not be briefly decided later on, but because the primary direct custodian of 10th schedule is only one person. As a matter of fact, there are problems sometimes speaker is disqualified. Then the persona designata, you start doing hunting for a deputy speaker, which is strictly not legal. And then nobody there at all, then your lordship perhaps will interview. So therefore, your lordships will not short circuit this process. And no other procedure exists for deciding how to give a voluntary membership of party except what is here in 218, which the speaker to his best ability decides. Today, in fact, your lordship is being asked to do 2 things by the other side. A, that this be decided first by the election commission. B,
what should be decided to this?
Decided first is what your lordship is told. I will let the EC decide it first. B, is the nature of what is a political party minus them or with them will be decided first, and thereafter the nature of the party will decide by the state.
That's just one submission for your lordship's kind consideration. Only on Kyoto Holo.
No, it cannot be, Mr.
That was Kyoto Holo. Mr. Rejoinder was cited. Just one second.
One sentence.
1 second. But Kyoto Holo said that while a show cause notice by a speaker is issued, no judicial review will lie till a final decision is taken. And that's why they're saying we ought not to have come at the stage when a notice was given to us on the 27th and then the order was passed. We came relying on Navam Rebia, which said the speaker cannot proceed with the matter. A constitution bench of this court had said the speaker will not initiate, continue, or proceed. So the issue was completely different, and their 32 is actually contrary to Kyoto because they are seeking this court to transfer all the jurisdiction of the speaker and decide it. And Mr. Sibbal presumes that we are disqualified and the EC today cannot be approached.
All right.
First issue.
Yes. Heard Mr. Abel Sibal and Dr. Abhishek Singhi, then counsel appearing on behalf of the petitioners in support of the application for stay proceedings before the Election Commission. Mr. Neeraj Kishan Paul and Mr. Maninder Singh have appeared on behalf of the private contesting parties. Mr. Tushar Mehta, then Solicitor General, has appeared on behalf of the Governor. Mr. Harun Dekhan, then Senior Counsel, has appeared on behalf of the Election Commission. Next. Having heard the. Sorry? Oh, yes, Mr. J.
What's it forgot me?
I'm so sorry.
No. Quite forget.
No, not at all.
Apologies. Having heard the Learning Council, we direct that there shall be no stay of the proceedings before the Election Commission. The IA seeking stay shall accordingly stand dismissed.
Very grateful. Extremely grateful.
Is allowed.